members of the travelling community could be evicted from council-owned, that is publicly owned land. And I think the decision is interesting in various respects, but probably most critically in emphasising that marginality, that is the marginal status of an affected individual or community in the eviction context, can influence proportionality analysis, that there may be a relationship between emerging domestic and European Convention protections in this context that we need to take account of, and that there is an important distinction to be drawn in this context between remedies for eviction and substantive merits-based determinations as to when eviction is or is not proportionate. So Michelle, I don't know if I can move the slides on or if you can move them on.
Yeah, no, I am handling the slides.
Thanks a million. That's great. So I thought this was an interesting quote to start with in terms of framing the dilemma we really have in dealing with unlawful occupation by the travelling community. And this is a quote from that recent decision of the Irish Supreme Court that I mentioned, that is Clare County Council and McDonagh, where Judge Hogan really captures the extent to which traditional legal lenses as applied particularly in common law systems, the focus of this discussion, really struggle to capture and accommodate the non-ownership interests that are held by members of the travelling community in terms of the occupation of space at different points in time. And in this quote that you can see on the slide, we see really a very refreshing acknowledgement by a common law judge of the fact that our traditional principles of property law really struggle to adequately respond to and accommodate the norms driving the demands of members of the travelling community in terms of occupation of space. Somewhat tantalisingly, that suggests that the decision might go on to really tackle, if you like, those systemic and embedded problems in the common law system. But as hopefully I'll be able to demonstrate, the decision is less transformative in its effects than that insightful quote might suggest lay ahead. The backdrop to this decision, which I want to put alongside the protection for the home in Article 8, is a particular provision of the Irish Constitution, replicated in some shape or form in various European constitutions, and that is a protection for the dwelling. So Article 40.5 of the Constitution in Ireland provides that the dwelling of every citizen is inviolable and shall not be forcibly entered save in accordance with law. And that was really at the heart of the McDonagh decision of members of the travelling community who were occupying council-owned land. This group in particular had previously been in occupation of settled accommodation, which had burnt down in a fire. They had then moved into private rented accommodation and ultimately ended up moving their caravans and mobile homes onto council-owned land. And the council took two actions against this group. The first was, in a more traditional sense, to seek an injunction for trespass for the unlawful occupation of the land. The second, somewhat more unusually, was an attempt to obtain an injunction on planning grounds on the basis that there had been unlawful development of the land by the members of the travelling community whilst in occupation of the property. So those two arguments were brought, and the council succeeded, if you like, at the first two superior court stages in the Irish system in obtaining a mandatory interlocutory injunction requiring this group to move off the council-owned land. And what came before the Supreme Court was the question as to whether these interlocutory injunctions should be upheld or not. And the key argument made by the applicants in McDonagh was to say that their Article 40.5 rights in respect of the dwelling under the Irish Constitution, coupled with their Article 8 rights under the European Convention to protection of the home, were such that the injunction levied against them was a disproportionate interference with those rights. So that was really the scene that was set in the McDonagh decision. And the interesting and perhaps somewhat surprising conclusion of the Supreme Court was to discharge the mandatory interlocutory order that had been granted at the lower stages. And we're still awaiting a substantial hearing following on from those hearings in respect of the interlocutory injunction. So moving on then to consider the, I suppose, key takeaways from the decision. Michelle, if I can just get the next slide, thanks. Great. An interesting feature of the decision was that it was perhaps the first of the decisions in the Irish context to really consider alongside each other the relative strength of protection of the constitutional protection that it was in play vis-a-vis the protection afforded by Article 8 of the European Convention. So Judge Hogan for the Supreme Court suggests that the protection in Article 8 is weaker, encompasses less than the corresponding constitutional provision. And I thought that was an interesting point for us to reflect on, which is to consider where Article 8 has perhaps often been perceived to be ahead of movements and developments in a progressive direction in domestic jurisdictions. This is one instance of a domestic constitution, if you like, being identified and interpreted as moving ahead of and going further than Article 8. And in practical terms, where is this additional or extra constitutional protection? Well, the first identifiable added value of the constitutional protection was in respect of the requirement of a connection with place. So as you're all well familiar, the idea behind Article 8 is that there's the need to establish on a factual basis some close continuing with the place in question in order to engage Article 8. Interestingly, the Irish court interpreted the constitutional provision to say no equivalent requirement, that it is a simple question of fact as to whether a person resides in a particular place or not, which determines the engagement of the protection for the dwelling. So unlike in the Article 8 context, there's no requirement to establish a degree of connection with place and no X factor, to borrow Lorna Fox O'Mahony's term, of some kind of degree of relationship with place required. It's a simple question of position in place at a moment in time. In fact, perhaps throws up some of the gaps that are left under Article 8 protection in respect of members of the travelling community by illustrating that a simple position of a caravan in place could be enough to trigger protection for the dwelling. The other forging ahead, if you like, of the constitutional protection identified provision as compared to Article 8 is in respect of the scope of application of the protection. So in various other decisions, the protection in the Irish Constitution for the dwelling excuse me, has been held to be horizontally applicable, not just vertically applicable, as compared to, as we've seen in recent decisions such as FJM, the identification of Article 8 is primarily only applicable vis-a-vis state organs or public authorities. So what we see firstly emerging from the decision is an interesting coexistence within the decision of constitutional and ECHR protections in respect of the unlawful occupation that was in issue and, as I identified in certain instances, the constitutional protection, if you like, moving ahead of the Article 8 protection. So moving on then to consider where this decision was taken by the European Court of Human Rights thereafter. If I can just move on to the next slide. So interestingly, and I see Porrick Kenna on the call here, I'm very glad to see Porrick. You can tell me what I'm misrepresenting on the Irish position, but also Porrick reminded me to consider the rejoicing somewhat in maybe the more innovative aspects of the Irish decision in McDonough. And certainly the Faulkner decision, where the European Court of Human Rights recently picked up and analysed the Irish Supreme Court decision in McDonough, does emphasise and frame the decision in quite limited terms. So where there was ambition that could have been seized upon in the Supreme Court decision, the tone strongly of the European Court of Human Rights decision is if you like, to quash, quell and minimise the ambition and scope of the decision, I think. So in Faulkner, the view of the European Court of Human Rights was that the Supreme Court decision in McDonough had to be very much read in and confined to the specific remedial context within which it arose. So the European Court of Human Rights tells us, since the object of the proceedings was to obtain an interlocutory injunction, the question was whether the appellants had an arguable case by way of defence. So that this wasn't an on the merits determination of the proportionality of the eviction, but was rather a more preliminary decision. In looking at the content of the Supreme Court's decision, the emphasis throughout the European Court of Human Rights decision is that really this is a decision at a moment in time that could have gone if certain factors played out differently at that moment in time. So, for example, at Supreme Court, a key factor was the risk of homelessness that was faced by McDonough and the rest of the group were they moved on from the council estate. The Supreme Court took a quite pragmatic approach and said, look, if we issue an injunction here, all that's going to happen is this group of individuals are going to trespass and be an unlawful occupation elsewhere. And the European Court of Human Rights acknowledges that point, but stresses that if at that moment in time alternative accommodation had been available to the applicants, the decision could well have gone the other way. Another variable picked up on by the European Court of Human Rights was the fact that the unlawful occupation of the land didn't pose any obvious immediate threat to the amenities of third parties or raise environmental concerns. And crucial here was the fact that these were temporary as opposed to permanent structures. And finally, the European Court of Human Rights picks up on the Supreme Court's emphasis on the failure of the council in question to fulfil the statutory obligations that it owed to the applicants in relation to traveller accommodation, and it accepted that that was on the facts significant. So in terms of the actual substantive factors that the Supreme Court looked at, that, if you like, speak to the question of marginality, the risk of homelessness and the failure to fulfil statutory obligations, there isn't a significant divergence between the Supreme Court decision and the European Court of Human Rights view of that decision in Faulkner. Both accept homelessness and non-fulfilment of statutory obligations are relevant considerations in assessing the proportionality of a proposed eviction. But what's crucial really about the Faulkner decision is to emphasise that in the context of an injunctive remedy, that decision is only made at a particular moment in time and can be revisited if circumstances change, so that this is not a final substantive determination of the question of proportionality, but rather a reflection at a particular juncture as to whether, taking these factors into account, the decision is proportionate or not. For a moment on the question of threat to the amenities of third parties or environmental concerns, excuse me, this really speaks to the question that I opened the discussion with, which is, can travellers' interests in respect of accommodation be adequately accommodated within the traditional structures of property law? And the emphasis on the lack of impact on third-party interests or amenities really signals that this decision was keeping within the traditional boundaries set by property law and not attempting to, if you like, overturn in any radical way the ordinary rights and expectations that property owners have, particularly private property owners, in respect of remedies in the context of unlawful occupation of land. So while the awareness was there on the part of the Supreme Court as to the discomfort in fit between travellers' interests in this context and property law structures, there's no appetite shown either at the domestic court level or in the European Court of Human Rights to take on that discomfort and that disconnection, but rather very much cleaves to the traditional view that property rights in this context decide the issue, are central to the decision-making process, and presumptively trump the non-ownership rights or interests that may be at play in the particular dispute. So let's move on to conclude. Michelle, thank you. So where might we go from here? I think a key agreement that emerges from the decisions that the Supreme Court in the McDonough decision and in the European Court of Human Rights in Faulkner is that the marginal status of an impacted individual or group is significant. Although, again, in terms of that slightly negative tone, the European Court of Human Rights in Faulkner is quick to stress in respect of that point, the point that Article 8 doesn't confer a positive right to a home or indeed to a home of a particular type. The other point emerging is that the impact of the requirement of a proportionality assessment prior to the deprivation of a dwelling may, I suggest, be more far-reaching in a context such as Ireland, where the relevant domestic constitutional protection is horizontally applicable as compared to in rights context. So, for example, post the McDonough decision, it's fairly open in a future case in the Irish context to argue that in the context of an eviction from a private residential tenancy, there must now be a proportionality assessment by an independent tribunal of that decision prior to the deprivation of the dwelling in question.
I'm not sure if she's also frozen in the rest of the, but I see people nodding. Yeah, okay.
Yes. Yes.
Well, let's wait if she comes back. Rachel, I'm sorry, but we lost you. You have your microphone off now.
Where did you lose me there, Michelle? Sorry.
I think like a minute.
Okay, sure. Sorry about that. So I'll take back to the point in terms of the relative impact of the proportionality assessment in the constitutional and the European Court of Human Rights context. And I was making the point that the horizontal application of the domestic constitutional provision in the Irish context means that, for example, we can still argue that there must be a proportionality assessment prior to an eviction in a private residential tenancy context, whereas that argument has been more or less foreclosed in the context of Article 8, for example, through the FJM and UK decision, the McDonald and McDonald decisions in the UK. So in this instance, the protection for the dwelling in the Irish context under our constitution is providing greater potential to incorporate proportionality assessments more broadly in our legal system in respect of eviction than Article 8 is in fact offering, it would seem. Final 2 points then. I think it is significant that the court at Faulkner, the European Court of Human Rights in Faulkner, accepted the point made by the Supreme Court that fulfilment of statutory obligations in respect of housing is a relevant consideration when it comes to the proportionality of an eviction, and where a public authority is not in fulfilment of statutory obligations, that should be taken into account, at least in considering the remedies in terms of enforcement of rights that are open to that public authority. Although, again, in terms of its cautious approach, the European Court of Human Rights in Faulkner stresses that it cannot be the arbiter or the adjudicator of whether or not a national housing body has fulfilled its statutory obligations. So it'll be interesting to see how that works in practice. And finally, I think this decision, the Irish Supreme Court decision in McDonough and the response to it in Faulkner, maybe really forces us to reflect on whether there may be a divergence in the case law in respect of eviction going forward in respect of the availability of remedies, particular types of remedies for eviction versus the substantive merits-based determination of the proportionality of particular evictions. The Irish decision in McDonough in that respect really didn't come out of the blue, in that we've had decisions in the past that have said that the grant of an injunction is ultimately an equitable remedy that's discretionary and crucially should not be granted in vain. So in circumstances where an injunction is simply going to prompt trespassing in another place, that the courts should be slow to grant that type of remedy. So it'll be interesting to see whether maybe this marks something of a turning point in a separation of analysis of the remedial and the merits-based stages of eviction disputes at least in the unlawful occupation context. So thanks very much for your time and attention, and apologies for the breaking connection there in the middle. Thanks, Michelle.
No problem, that can happen. Thank you so much for your very interesting presentation. We have about 5 minutes for questions. Is there anyone who has a question? You can virtually raise your hand. I think you can even applaud in this program. Yes, Irina, please go ahead.
Thank you, Michelle. Thank you, Rachel. I have a clarification question, because I didn't quite get why it makes a difference that that in the Irish Constitution, or that the Irish Constitution makes the right to housing in Ireland also applicable to private parties. To what extent does that influence the proportionality assessment? Because, as you said, also in the cases in previous case law, the European Court of Human Rights had said that that there should be it said that there shouldn't be proportionality assessments in private contexts. So, but I wonder if you could elaborate a bit on like the technicality, like what did the European Court of Human Rights particularly say to that extent that makes you think that? Thank you.
Sure, I suppose,
I don't know, understandable.
Taking the Irish point first, important to emphasise that what we're talking about here is not a right to housing in the Irish Constitution. We don't have a right to housing. What we have in the article that I was discussing is a negative protection for dwelling. Okay, so it's not hooked to property rights of any kind. It is simply the fact of dwelling in a particular place, whether lawfully or unlawfully, that will trigger the protection for the dwelling. And really, in the past, the view had been that that provision was more or less an equivalent to the US search and seizure provision. It had traditionally been used to control entry with search warrants, for example, into domestic dwellings. So it's not a substantive right to a housing. However, it has been recognised as horizontally applicable, as between private individuals, rather than merely vertically applicable. So why I see that as significant, first of all, I think it's a feature of our jurisprudence in relation to that article that if you like, the courts and the legislature haven't fully realised the implications of yet here, because what the McDonough decision accepts, very much in line with the European Court of Human Rights case law, is that if you're going to evict somebody from their dwelling, that decision needs to be on the basis of an independent assessment that that eviction is proportionate. Okay, but as we know in the European Court of Human Rights context, so far it seems that that assessment only has to take place where the eviction is in some way linked to an exercise of public power, okay, or public control. It's not quite as narrow as only a public authority landlord, but the decisions do seem to suggest that where you're dealing with exclusively private parties, no public element at all in play, that proportionality assessment may not be required. In contrast, I think in the Irish position, we're now open to the possibility that in every instance where somebody is going to be evicted from their home, whether by a public or a private decision, that decision has to be mediated in some way by an independent proportionality assessment. So, for example, in the context of private residential tenancies, an eviction there requiring a proportionality assessment, where a receiver seeks to exercise receivership powers over a mortgaged property that's in arrears, that decision might now require a proportionality assessment by some independent decision maker. So that's, if you like, where I see the difference emerging, and certainly as I read the European Court of Human Rights case law following the decision in the UK Supreme Court in McDonald and McDonald, which was that purely private landlord-tenant disputes weren't covered by the proportionality assessment. The FJM in the UK decision in 2018, I think it was, very much seemed to accept the analysis of the Supreme Court in McDonald and say, if you have national level legislation that works out the balance of rights in the private context between landlords and tenants, the ECHR will more or less respect that. So I hope that answers your question somehow.
Thank you so much. For the rest, I would like to ask you to save your questions until the end of the session so we can continue with the presentation of Michel Vols. Rachel, again, thank you very much for your very interesting presentation, and hope we can continue the discussion about this topic at the end of all the talks. Michel, the floor is yours.
Thank you so much. If you can move on to the next slide. Thanks so much. It's great to present in the EVICT talk series. I've never presented in my own series or in our own series, so this is the first one. So today I'm going to talk about squatting in the Netherlands and how European law changed the way how we deal with squatters. Mainly, the presentation has two objectives. So first, the objective is to tell you something about the Netherlands and Dutch law. For you, most of you, Dutch law and Dutch case law is inaccessible because it's in Dutch. Most people don't speak Dutch, so it's good to know what happens in the Low Countries. So it's a good case, or it's a good illustration how you can deal with Article 8, right to housing in a country where most people don't understand what's happening, right? There is a bigger objective, I would say. The bigger objective is to show what might happen if a country embraces the proportionality or the right to housing. Or, as I call it in a previous paper, what happens if you transform a country into a proportionality paradise. So we see, as Rachel already described, in the UK there is a lot of resistance of embracing proportionality in private rental cases. Maybe the same in Ireland, but they have their own constitution that deals with the topic. But what happens if a Supreme Court just embraces proportionality in all types of rental relations, but even in squatter cases? What happens? So what happens with the squatters? Are there more squatters? How do they enjoy legal protection? Do they use it? What's the effect of because the Netherlands embraced the proportionality principle in all kind of cases. What happens, and how does Parliament and politicians respond to that? Because they don't like proportionality assessment in squatter cases. So I'm going to tell you more about that. So if we can move on to the next slide, you see a picture from the 1980s. The Netherlands had a huge squatter scene. So up to 2009-10, squatting was not illegal in the Netherlands. So from a criminal law perspective, of course, it was seen as an infringement or a violation of someone's property right. But from a criminal law perspective, it's not illegal as long as the building was not occupied for a year or longer. Right? So you saw that there were just lists of buildings, and squatters had teams going around checking whether buildings were empty for a year or longer, and then you can easily squat it. You put a bed, a table, and a chair in there, then you call the police and you said, this is my home, and then you were protected by law, and the property owner and government could not evict you very easily. We had a huge squatter scene, thousands and thousands of people, mainly in Amsterdam, but also in other towns, such as Groningen, student towns. And we even had big squatter riots. So here you see in the 1980s, there were big riots. They even the squatters rioted during the inauguration of the Dutch Queen in the 1980s. And that was kind of a turning point where most of the population said, so, okay, we don't support this really activist squatting movement. So it diminished a bit, but still up to 2010, it was not illegal to squat. But in 2010, then the political tide turned. So if we go to the next slide, Parliament enacted this Squatting and Vacant Building Act in 2010. It's called the Squatting and Vacant Buildings Act. So it includes a ban on squatting, and it also includes a way to tackle problems with vacant buildings, right? So the municipality can oblige property owners to use vacant buildings or put tenants in them. These powers are never used. The squatting ban and the possibilities to evict squatters, they're used very often. So it was more like a political framing, I guess, to make it more acceptable to the audience that it also tackles the problem with vacant buildings. That's not actually what happened. It was mainly a very right-wing bill or act that tackles squatting. So what does it mean? In Article 138 of the Criminal Code, there's a ban on squatting. So even if the building is vacant for longer than a year, you cannot squat it and you can be criminally prosecuted. Then how to get rid of the squatters? property owners can go to court as they did before because of a breach of property rights. So they can start themselves. The mayor can also close a squatted building in case of a breach of the public order. So if there's a fire hazard or there are riots, doesn't happen that much. The most important power is that public prosecution service, so it's the criminal law department, can initiate eviction proceedings. Basically, they go to the squatted building and they say, we will evict you within 6 weeks. So that was the plan. So the criminal prosecutor can just decide on his own or on her own to evict the squatter. If you go to the next slide, we find that it was not that easy because the squatters relied on Article 8. We have Article 8, everybody knows Article 8 probably in this audience, so there's a right to private and family law, home and correspondence, and of course you can limit this right, but there are certain restrictions. For sure it should be necessary in a democratic society. So how to interpret this requirement, then we go to the next slide. That's the famous case of McCann in 2008. Rachel also referred to it in her presentation and some newer case law, but this was basically the phrase that is used all the time, that a loss of one's home is the most extreme form of interference with the right to respect for a home, and that any person should be able to go to a court to have the proportionality tested of this eviction, right? So that's the main line of reasoning. In newer case law, as Rachel already explained, there is like an exception for private rental relationships or tenants in the private rental sector. I cannot understand why that is the case if you read this specific phrase, but still they made this different. But in the Netherlands, the Supreme Court, already in 2011, if you go to the next slide, acknowledged that given Article 8 and this McCann decision, squatters should have the opportunity to have a proportionality of the eviction determined by a court before the eviction actually takes place. Because first the government, when they were sued because how it works, so the public prosecutor goes to the squatters, announces that there will be an eviction, then the squatters went to court and they requested a prohibition for this eviction, to prohibit the public prosecutor to use his power to evict the building. That's basically it. Because it is disproportional to evict them. So the squatters go to the court, and then they ended up in the Dutch Supreme Court. Dutch government says so Article 8 is not applicable because they're squatters, they don't have a right to housing or they don't have a right to home, so they cannot rely on it. Supreme Court said no, that's not the case. They have a right to housing, they can rely on it, given the McCann case, given Article 8. Then the government argued, so okay, but they should be evicted, and then later, at a later stage, they can go to court and have the eviction checked by a court, but then they're out already, right? So they can go to court like weeks after the eviction took place. And then the Supreme Court, Dutch Supreme Court, said, no, that's also not the case. They should be able to go to court before the actual eviction takes place. And then in its reasoning, it says, and I translated it in English, of course, so it acknowledges that in most cases, the interest of the owner will weigh heavier. But it's not always the case. So it can be that the interest of a squatter in a concrete case for a limited period of time will weigh heavier. And it's also not the case that because of the unlawful occupation of the squatter, that the squatter cannot rely on the right to housing, according to the Dutch Supreme Court. So it basically embraces the Article 8 reasoning, even in squatter cases. So what happened after that? Can you go to the next slide? So we had lots of squatters going to court. So after the ban entered into force, we had squatters going to courts all the time to ask for a ban on the eviction. If we look at that in numbers, so how does it work? We saw that in 1997, 79 cases took place in Amsterdam, Utrecht, or Haarlem. So Amsterdam, of course, is the capital. Haarlem is a city very close to Amsterdam, and Utrecht is one of the third city in the Netherlands, or the fourth city in the Netherlands. It's also everything is close in the Netherlands, but still, it's 45 minutes from Amsterdam. So it's all concentrated in the big big towns in the Netherlands. So only in Amsterdam we know exact how many squatter cases. There were 560 cases of squatting in Amsterdam. In 30% of the cases, the squatters requested the court to prohibit the eviction. So they made use. So in the majority of cases, so even in this proportionality paradise, the Netherlands, where squatters can just go to court and have the proportionality tested of their eviction, 70% of them don't go to court. So the floodgate argument that you say, if we allow squatters to go to court, it's not valid, I would say. Right? So in the Netherlands they can, but they only use it in 30% of the cases. And what's interesting that only in 7% of the cases, a case leads to a court hearing. So that means that in 30% of the cases, the squatter announces that they will go to courts to ask to prohibit the eviction. But only in 7% of the cases, they actually go to court and a court has to decide whether the squatter will be evicted or not. In the majority of the cases, then the court decides and it weighs the interest, but in the majority of cases, they say the interest of the state of the Netherlands or the public prosecution service and the property owner weigh heavier than the squatter. But there are some cases where these squatters win. And that's the next slide. So this is a specific group of squatters. So it used to be the activists, the left-wing activists that just squatted buildings because they're against property rights and so on. That's the 1980s. In current days, of course, they're still activist squatters. But the majority of them are homeless people that actually don't have a home and just find a home. And the second biggest group is a group of illegal immigrants. So this is the group We Are Here. Wij zijn hier in the Netherlands or in Dutch. And basically they are immigrants that are refused to, the government refused to give them a permit to live in the Netherlands. But they cannot, or they claim that they cannot return to their home country because often it's unclear what's their home country or their home country doesn't let them in. So they're basically stuck in the system. So they don't get a permit, they need to leave, but they cannot leave. And most of the time they don't want to leave because they feel insecure and unsafe in their home country. So they say, so we are here and we're not going to leave. They are not given shelter, or for a long time they were not given shelter or really, really, really crappy shelter. So they had to live on the street during the day and they can only sleep at night. Crappy conditions, right? So they said, we don't want to live here. We just squat buildings. So they squatted a lot of buildings. And it was a big group, 80 people. They squatted schools, offices, things like that. And they had some supporters among Dutch activists and NGOs as well, right? So they had some lawyers that represented them. So what happened in this case? So if you go to the next line, this is a Court of Amsterdam ruling, but there are more. And it's a very interesting ruling. So in this case, the court ruled that they have no access to social services and are dependent on the help of others. Returning to their own country is often problematic. In the view of this court, in its preliminary relief proceedings, so that's the procedure that deals with the ban on the using of eviction powers, it's inhumane to evict this group of asylum seekers who have exhausted all legal remedies in the current winter weather conditions. And then they said, so after all, eviction will probably result in the fact that in any case they will not longer have shelter during the day and will be dependent on the street. And then their interest should weigh heavier than the interest of the state of the municipalities of Amsterdam. So they actually won. So you can win your case, and I think that's special in most European countries, or at least in common law countries. That as a squatter you can win your case and rely on Article 8 and then win your case. Of course, that's not the majority of cases, because the biggest impact is on the next line. So the main impact of this type of decisions is not that so if you as a legal scholar only focuses on the published case law, you find this one or two cases where they won, and you can say, so in most cases they don't win. I think that the biggest impact in providing them with legal protection and becoming a proportionality paradise is that you can delay your eviction. That's the same in a paper I wrote about landlord-tenant law. I just posted it in the chat. We also found that in the Netherlands, private tenants and also public tenants can rely on Article 8, can rely on proportionality in their eviction cases, often they don't win, and even if they rely on proportionality defenses, they lose more often than tenants that don't rely on proportionality in their defense. So that's a weird finding, right? But if we look at how long does it take before you bring a tenant or a squatter before court, it's much longer than in other countries. So it changes the strategy of municipalities, public prosecution service, and landlords if you allow residents, so squatters, tenants, owner-occupiers, to use the proportionality principle. So that's I guess, an interesting finding. So the main impact is that it's delayed. And then I come to the last slide, I guess. Because politicians don't like this type of protection. So if you just look at the numbers, only in 7% of the cases, of squatted cases, people go to court. So or they have a court hearing. So that's only 7% of around 500 cases. So there are under 50 cases in the last 7 years. So it's not a big pressing issue to limit that type of legal protection, I would say. Still, politicians in last year, there were elections. Two right-wing parties announced that they wanted to introduce this Enforcement of the Squatting Ban Act, where they said the delays take up to 6 to 8 weeks. And therefore, we should limit the level of protection over to squatters. How does it look like? According to this act, the public prosecutor has to request an examining magistrate to issue an eviction order. So that's something typically Dutch. So there is a magistrate, a judge, that just supervises the criminal law proceedings. If you're arrested, and in a number of in 10 days' time, you need to be brought before this examining magistrate. So it's not like a private law court or a criminal law court. It's a magistrate, but it doesn't sentence you or cannot sentence you to jail. It just supervises the public prosecution service. I'm not sure whether you have the same things in your own jurisdiction, but it's just a judge. It's in Dutch for the Dutch-speaking people. It's a rechtercommissaris. So it's not the judge that decides in your case, but it just checks whether your prison conditions, for example, are in line with the European Convention, for example. They decided that the public prosecutor has to request this specific rechtercommissaris, this examining magistrate, to issue the eviction order. So that saves time because it's in the act that this magistrate has to decide within 3 days after the public prosecutor asked for an eviction order. So within 3 days, a squatter can be evicted or after 3 days, the squatter will be evicted for sure, if the examining magistrate issues the eviction order, right? So what's interesting that the public prosecution service and also municipalities, for example, the mayor of Amsterdam, were against this act. So they were opposing this act. Why? Because I think it looks like it's helping property owners, it's against squatters, and so on. But I think they made a mistake. And it's an interesting mistake because probably there's more legal protection now provided to squatters than it was before. So the Netherlands is even more a proportionality paradise. So how does it work? First, the municipality of Amsterdam and the public prosecution service said, so not every case takes 6 to 8 weeks. So only in 7% of the cases, people went to court. So in 93% of the cases, or there were court hearings. So in 93% of the cases, we evicted them within 2 weeks, for example, because they said they don't oppose the eviction. But in this case, every eviction should go to a magistrate first before the eviction takes place. So that's also the second point. With this new act, every case will have to go to court. So in the old procedure, there were 93% of all the cases that didn't end up in a court hearing. In this case, it's now 100% of all the squatter cases will go to court, and you have a judge looking at the court or at the eviction and at the proportionality of the eviction. And then the courts already said 3 days is not enough to conduct a proper proportionality test. So we will need more days than the 3 days that you set in this act to do the proportionality testing. And now it takes us much more time as a court and as public prosecutors to do this, because we have to process like dozens of cases every year, whereas in the last year we only had to do 50 cases in 6 years. So there was opposition against this. Like everybody, except like in public prosecutions, there were municipalities advisory board. They said don't do this, but still the act was approved by Parliament, and it now takes already almost a year before the act enters into force. So we don't know how this will end up in practice, because the public prosecutor and the court said, so we need at least a year before we can work with this act, because it will take so much time to deal with all these squatter cases. So it will only enter into force into July 2020 or 2022. So that will be in a few months' time. So let's see whether the Netherlands is going to be an even more proportionality paradise, right? So or that we even embrace more proportionality or not. So that's what I wanted to talk to you today, or wanted to tell to you today. If you go to the last slide, if you want to know more about the EVICT project, it's just the usual commercial. And if you want to ask questions, you can do that online on Twitter. But I'm most happy to answer your questions right now.
Thank you very much, Michel, for your very interesting presentation about squatting in the Netherlands, and where we are, of course, based. And I see a question from Natalie. Please go ahead. Natalie, you can open your mic if you want to. We cannot hear you.
Can you hear me now?
Yes, yes.
Okay, so sorry. Hi, my name is Natalie Medina. I'm from Tonga Territory in so-called Los Angeles, California, the US. I just had a question in particular about how before the Act of 2021, there was a limitation on, you said that only about 30% of cases were being actually dealt with in the courts. Do you have any idea why 70% of cases were not being challenged? Was it because squatters had lost their connection to wherever they were? Just any idea for why that was?
Yeah, so you're right. So only in 30% of the cases in Amsterdam, where the majority of cases take place, the squatters decided to rely on their right to housing or their Article 8. Right? So in 70% they did not. So there's no real research being conducted on why they decided not to do that. I guess because a lot of squatters don't have legal representation, right? So it might also be the case that they just decide to wait for the eviction takes place and then find another place to squat, or they find any other type of shelter. But actually we don't know because there's no proper research that's being conducted. What we know is that basically the squatters also know that the possibility to go to court delays their eviction up to 2 to 3 weeks. So basically, if the police and the public prosecution find out that they squatted this building and they want them out, then they have 2 to 3 weeks to find another place. So it's just like a carousel where they hop to a new building. And then if you announce that you will actually go to court, it will take somewhat longer. And according to the right-wing opposition or the politicians, it takes 6 to 8 weeks. But if you look into the data, it will take around 2 to 3 weeks longer. So most cases are being handled within 3 weeks. But you see, for example, the We Are Here group. Yeah, so they just decided to hop to another building, and then if they need to leave there, they hop to another building. What's also interesting is that Dutch government then realized that, for example, the We Are Here group should be offered some kind of shelter and not only the crappy shelter. So then municipalities, for example, Amsterdam is a very left-wing municipality, said so, and there were some political parties that said so we should offer them proper shelter, and now there's even more there's proper shelter at the moment. So that also gives them an incentive not to squat anymore, but just go to the official shelter locations. Does that answer your question?
Yeah, it does. Thank you so much.
Thanks.
Thank you so much for your question. I think that the best way to move forward is to move on to the next presenter in terms of time and to save the questions at the end because we're already running a little bit out of time. Michel, thank you again. And Sarah, without further ado, please, the floor is yours.
Thank you so much, and thank you everyone for having me. At the moment, we are experiencing something called load shedding in my part of Cape Town. And I don't know if you've heard about it, but it basically means you don't have electricity for 2.5 hours. And basically the national grid can't handle the electricity, so we don't have, but just switch it off. you know when they'll do it, but you can't help it. So I'm going to turn my camera off while I'm talking. I have enough battery, but I'm just scared that maybe the connectivity won't be that great. And then during the questions, I'll turn it on again. Okay, so let me start talking. Okay, so I'm going to talk to you on proportionality in evictions. And if you stop hearing me, please just no, how will you tell me? I hope I'll figure out if you can't hear me anymore. I'll just look at your faces and see if they're still moving. So what I'm going to do is I'm going to just give you a basic overview of what is happening in South Africa. I will start by showing you the relevant South African constitutional sections, and I will also compare that to the corresponding Article 8 in the European Convention, just to show you how it compares. And then I will discuss South Africa's unique context when it comes to evictions, and explain how this has led to a much more far-reaching protection than what the European Court has granted, even though the mechanisms are very similar. You can go to the next slide. Okay, so this is the South African constitutional section, and it deals with evictions. And it says that no one may be evicted from their home or have their home demolished without an order of court made after considering all the relevant circumstances. And then no legislation may permit arbitrary eviction. So it's clear that evictions must be court ordered, first of all, and that they must not be arbitrary, and all relevant circumstances must be considered by a court. It's already different from what Michel has said. It happens in the Netherlands. So this on its own does not necessarily provide for a proportionality determination. However, read together with our more general section on constitutional matters, it does. So if you go to the next slide, section 172 of the Constitution provides that when deciding a constitutional matter within its power, a court may make any order that is just and equitable. So if a court is deciding on a constitutional matter, which an eviction is, then the order it makes must be just and equitable. Next slide. I have many slides, so you'll have to listen up. So read with section 26.3 of the Constitution. This means that the court has a duty to grant an order that is just and equitable based on all the relevant circumstances. So that is our proportionality requirement, basically, in our Constitution. Next slide. So I just wanted to show you Article 8 again, so you all know this section off by heart. So I'm just showing this to you to prove that we're not that different from you here in South Africa. Section 26.3 similarly protects against the loss of a home by requiring it to be lawful. So you have the words lawful, and we have the words in terms of a court order, and requiring it to be just and equitable, which is similar to your proportionality necessity requirement. How this protection mechanism has been applied is, however, a bit different. Michel and I actually wrote an article, or maybe it was 2 articles, comparing this protection. And one of the main reasons for the difference between the application of these mechanisms is the fact that the contexts differ. So I'm going to discuss the South African context a bit and explain to you what the effect of that is on evictions and on our proportionality test. And then I will compare it somewhat to the European context. Next slide. So a lot of what is happening in our courts and what has been inserted into our constitution is influenced by our past. For years, South Africa was governed in terms of a discriminatory regime called apartheid. So in terms of this regime, people of different races were not allowed to live in the same areas. The best areas were set out for white people, and black people were forcibly removed from those areas and forced to stay in areas far away from the cities where there was not a lot of work and the land wasn't really farmable. The black people that worked in the white areas were allowed to kind of stay on the peripheries of white areas in what was called townships. When apartheid ended, black people flocked to the cities in search of work. They often ended up living in these townships or creating new informal areas where they lived. These areas are also referred to as informal settlements or squatter camps based on the fact that occupation is often illegal. So it's often on vacant land, and the structures that are used for housing are often made from informal materials such as wood and corrugated iron. So these are the kinds of houses that they live in these areas. This is one such township or one such informal settlement. And then the next slide, you'll see another one. So you'll see those are the toilets that all of the people, this is a very big township, you just see a part of it, and those are the toilets that the people have to use. Next slide. Next slide. Can you hear me?
Yeah, sorry, sometimes there's a hiccup in the,
oh, that's fine.
delay.
It's just another picture. So in the next slide, you'll see that these informal settlements are adjacent to you can see, to very rich areas often. So it creates extreme spatial injustice. I think the Times magazine did a whole feature on this where they have all of these aerial pictures where you can see the complete spatial injustice with affluent areas on the one side and right next to it these very poor areas that are very overpopulated. Next slide. So in addition to occupying vacant land, people moving to the cities also occupied abandoned buildings. So these buildings were not maintained, they were abandoned, they were dilapidated, and they posed many safety risks like fire risks, and there wasn't necessarily running water. So this was going on at the same time and is often still going on. Next slide. So that's just another one. You can go to the next slide. So such large-scale unlawful occupation by the desperately poor is not limited to the immediate post-apartheid time. So vacant pieces of land, private or public, are still often occupied unlawfully by people erecting informal structures. So sometimes this happens gradually, and people gradually start putting up one or two shacks or informal structures on a piece of land. And sometimes it's more organized. So people have complained about so-called land grabs, where a group of people target a specific piece of land. They decide on a date, and then they get like vehicles come there and drop off material to build structures with. Then within like a day, they start erecting structures and start living on the land. So this is often said to be politically motivated or orchestrated. Then the next slide. And COVID did not help at all with our informal settlement problem. During COVID, especially in Cape Town, tents sprouted all over the place. So the city had created these tented camps for the homeless during lockdown. But the homeless took these tents away from the camps and then just used them to set up camp wherever they wanted to. And the lockdown regulations also basically made it very difficult to get an eviction or even to prevent people from moving onto land, or the cases during lockdown made it very difficult to prevent the state from people unlawfully moving onto land. So that made our situation even more difficult. Next slide. So all of these slides I showed you up to now were of occupations that were unlawful. The informal settlements are often unlawful. So is the occupation of abandoned buildings and the land grabs and the tented villages that are sprouting everywhere. So this means that South Africa has an eviction problem. It has an unlawful occupation problem, and that causes an eviction problem. These categories of people often face evictions, and these evictions are often large scale. So I'm focusing on large scale evictions. We have normal evictions that you experience in first world countries too, but I'm going to focus on our large scale evictions. And the people often have nowhere to go. So this is a picture of the City of Cape Town's eviction team, and they call them the red ants because of what they're wearing. They are brought in when an eviction order has been granted, and they just go in and they remove the occupiers, they remove the buildings, they break everything down, they destroy everything in sight. And they're often also sent, when people try to occupy land, they're sent to prevent the occupation. Next slide. So that's just a little bit about our context. You can see that we often have large-scale evictions of desperately poor people that cause large-scale homelessness. So the people that are evicted in these situations, they are homeless. They don't have anywhere else to go. The people that face evictions are often black people, and often the displacement and discrimination during apartheid can at least in part be blamed for their disproportionate suffering. This means that an approach is needed that takes into account the suffering and the historical background that gave rise to it. So that's one of the aims of our Constitution, to be sensitive to this context and to reverse the ills of the past. And it's for this reason that Section 26(3) aims to protect against the loss of one's home and requires all relevant circumstances to be taken into account when a decision is made regarding evictions. However, this is not the only interest of unlawful, it's not only the interest of unlawful occupiers that are relevant, and I think that's more obvious in the European context. So there are many different interest holders that are involved, primarily the interest of the evictee and the evictor. You can, next slide. So our Constitutional Court has found that it is the duty of the court to balance these opposing interests and bring about a decision that is just and equitable. The use of the term just and equitable relates to both interests. That is, what is just and equitable not only to the persons who occupied the land illegally, but to the landowner as well. So that's why I have that scale there. It makes me think about a scale. On the one hand, we have the evictee, and on the other hand, we have the evictor. Next slide. So if the interests of the evictee weigh more heavily in favor of the eviction, then the eviction will be granted. Next slide. And the other way around, if the interest of the evictor, now I can't remember which one I said, the evictee weighs heavier, then an eviction will not be granted. Next slide. So what our courts have found is that when the land is privately owned and needed, the eviction would usually not be just and equitable. So private ownership on the part of the evictor, usually the courts have said, would weigh so heavily that an eviction must be granted, that it would be proportionate to grant an eviction. Next slide. In Changing Tides, the court said, in most instances where the owner of the property seeks the eviction of the unlawful occupiers, whether from land or the building situated on the land, and demonstrates a need for possession and that there is no valid defense for that claim, it will be just and equitable to grant the eviction. Next slide. So the reason for that, the reason why if it's privately owned, it would be proportionate to grant an eviction, is because private landowners in our Constitution have a right not to be deprived of their property arbitrarily. So the idea is that if an eviction would not be allowed, then that might be considered arbitrary deprivation of property. Next slide. But the problem comes in where the eviction would cause homelessness. Next slide. So this is because our courts have said an order that will give rise to homelessness could not be said to be just and equitable unless provision has been made to provide for alternative temporary accommodation. Next slide. So what that basically means is we've got a problem. On the one hand, the courts have said it won't be just and equitable to grant an eviction, to refuse an eviction if it's privately owned. And on the other hand, the courts have said it won't be just and equitable to grant an eviction if people will be homeless. So those are completely at odds with each other, and it makes the court's life very difficult because now there isn't one interest weighing more than the other. So what our courts have done, and that is probably quite unique and not something that happens often in the European context, is our courts have turned to the state and said that the state must provide the occupiers with at least temporary alternative accommodation. Next slide. So that just basically removes, so our courts have said the state must provide with the occupiers with alternative accommodation. And why is that? It is because our constitution actually has a socio-economic right, the right to housing, which, as Rachael has said, their constitution does not have that. So it's possible for our courts to rely on this section 26(2) of the constitution that places a duty on the state to realize the right of access to adequate housing. And our courts in eviction matters have actually interpreted this section to basically create a duty on the state to provide at least temporary emergency accommodation in eviction matters. Next slide. So that basically removes the homelessness factor and makes it proportional to grant an eviction. So that is our unique view, or our unique approach, is that we actually say we can't balance these interests. So we don't deny the eviction. We say the state must take care of the people being evicted. Next slide. A question that is arising at the moment, or it seems to be arising, is where the emergency accommodation must be located. So some decisions have required it to be, and that's constitutional court decisions, have required it to be as close as feasibly possible to the eviction site. So this could be very expensive if people are occupying expensive occupying land in expensive areas, and it could be a very big burden on the state. I recently submitted an article on this, so I hope to contribute to the discussion. We'll still see what happens to that article. But I could not find any international or foreign law requiring alternative accommodation to be close where the person was evicted from. All I could find that location, when it comes to accommodation, is important, but it doesn't talk about location in a specific area, just that location must be close to schools, jobs, and amenities. So that's unique to South Africa, and I'm not sure whether it's a very good decision, but we'll see what happens. Then the last slide. So this slide, I just wanted to briefly compare the South African proportionality requirements to the European ones. So in Europe, the proportionality must often be raised as a defense, and in South Africa, courts always have to apply the proportionality analysis. In Europe, it's often not assessed. Like Rachael has said, horizontally, it's not necessarily applicable. And when and often a court would say that the legislation that is in place sufficiently balances the interests involved, whereas in South Africa, it is applicable horizontally, and people are often successful when they rely on the proportionality defense, or when the just and equitableness requirement is applied. Then we've also seen that the effects are different. So in what Michel has said, in the Netherlands, maybe the best you can ask for is a delay, but in South Africa, the best you can ask for is accommodation close to where you were evicted from. and even maybe a complete denial of the eviction, but that hasn't happened in private evictions, really. Thank you so much. Yes, you can ask your questions. Thanks for having me.
Thank you so much for your very interesting presentation about yet another sort of case study about a country. Very interesting. I certainly have some questions. But first, let's give the floor to other people. Is there anyone with a question? And you can raise your hand by clicking on the right side of the screen. Go to people, and you see the list with names, and below you can see a raise hand. Anyone with a question? Yes, Tola, please go ahead. We can't hear you, so maybe you still have your microphone off. Tola Amodu, you can ask your question if you want. I can also unmute you. Oh, I can't, apparently. You can also ask your question in the chat if you want. Let's see if anyone else has a question first. Someone with a question. Alessandro Dinisi. Yes, please go ahead.
Okay, good evening. I have a general question for all the speakers that I'm really thank you for this interesting meeting. It's a general question about the I try to explain myself. A general question about the horizontal effect of proportion. In general, I think it's just a suggestion that in legal system there is no room for self-help, no? Private enforcement of property rights. So my suggestion is that the proportionality can be always conceived, the eviction can be always conceived as an act enforced by public authority. So my point is, if we can conceive positive vertical duties always in horizontal relationship, and if a proportionality test, and in this sense, my object is the European Court's case law, European Court of Human Rights case law. If proportionality can be conceived as an assessment addressed toward public authorities that enforce a private eviction. And in this sense, if we can conceive rehousing positive duties, even in eviction, in private eviction, and if a possible suspension of property right can be compatible with the time in which, a reasonable time in which public authority is put in charge of rehousing solution. And if you think in general that this can be the way in which European Court of Human Rights can develop, thank you so much. And I hope that the question is understandable. Thank you.
Yes, Sarah, go ahead. Your microphone is still off.
No, I just wanted to also ask a question, but I think maybe the Europeans should first try to answer that question, because in South Africa, it's completely different to Europe.
I suppose I would just say that I agree very much with Alessandro's analysis, in the sense that I don't find the analysis of the European Court of Human Rights in terms of distinguishing between horizontal and vertical effect in this context terribly persuasive. And you know, I think as Michel suggested, the McCann principle logically applies to both public and private evictions, and I think that's where the logic is going to take us in our Irish constitutional law, is to have it horizontally applicable. I like your idea that we just take the act of eviction as a public act and use that as a trigger for proportionality analysis. I would agree with that. And the idea that then, if I understood you correctly, the idea is that we impose, drawing on the South African approach, really, I think, a rehousing duty on the public authority and allow a reasonable time for the public authority to take charge of the housing solution. That again seems to be eminently sensible. I suppose my question around that approach, and maybe around the South African approach that Sarah might be able to speak to, is what degree of judicial supervision of that interim period, if you like, where the eviction has not yet taken place, in awaiting the public rehousing decision, what degree of judicial supervision is there of that interim period, and what degree of judicial supervision is it reasonable to expect on an ongoing basis of that interim period where we're moving between the eviction from private housing and the rehousing by a public authority? But I broadly agree with most of what you said, Alessandra.
Do you want to respond, Michel?
Yes, so I agree with you, Alessandro. And I think Sarah and I also paper. I put it on in the chat, a link where we actually make that case. That the FEM case judgment doesn't make sense, right? So it's the court that decides that someone has to leave his home or her home, and therefore there's a state authority being involved in this case. So it's a vertical relation. It's a different relation than, for example, the squatter case, where there's like only the state that tries to get rid of the squatters. Here there's a private property owner, so I see that the balancing might be different, but it's the court ordering someone to leave his home, so therefore Article 8 is applicable. And then the result of the weighing of interest might be different, but it's a strange move from the European Court. And it's also interesting that it's only an admissibility decision, right? So they made this decision in the admissibility stage. So therefore you could also argue, so you should do it again, because you should have maybe even a Grand Chamber hearing about this case. But of course, UK is not going to ask for that because they're happy with the results. I'm not sure about FEM, but let's wait. There will be another case maybe going to the real, or going through the admissibility stage, and then to have a proper substantive assessment by the court. And what's interesting is in the Netherlands, there's no discussion about is there any horizontal effect of the proportionality analysis? No, they just acknowledge that. And then the weighing of interest is different. So if you have a private landlord, then your chances of winning the case, if you're a private landlord, your chances of winning a case are higher than if you're a public landlord. What Article 8 doesn't say is that you have a right to alternative accommodation after being evicted, right? So that's I guess why the Dutch courts are willing to embrace it. What they're not willing to embrace is the protection provided by the International Covenant on Economic and Social Cultural Rights. If you look at that decisions, for example, the Bien Jasia case, or even newer cases or decisions by the Committee on the International Committee on Economic and Social Cultural, or the International Convention on Economic and Social and Cultural Rights, they basically say in private rental cases or in any horizontal cases, there should be alternative accommodations. Otherwise, the eviction is in violation of the International Covenant on Economic and Social and Cultural Rights. Courts don't accept that that's applicable in the Netherlands, and even the government said so. No, we're not going to ratify the optional protocol that allows Dutch people to go to the committee because of these judgments. So we don't want to get all these judgments against the Netherlands. So that's basically a backlash, I would say. So I think when the European Convention or the European Court is going to rule that there is a requirement for alternative accommodation in all cases, then I think Dutch courts will be less happy to embrace horizontal application of the convention. I hope that's clear. Yeah. Maybe Sarah can also, Sarah from an outsider perspective might be interesting to hear what she has to say.
I just wanted to comment on what Rachel said. In South Africa, we do have judicial supervision. Like, the court wouldn't allow the eviction before the accommodation is provided. So it's linked. And it's called a structural interdict, which basically means the court supervises the whole process. So it will require people to come, the parties to come back to court to explain what has been done, the state to explain where they will accommodate the people. So the eviction will never take place, and then the state must provide. It's linked, and the court supervises it often. Can I steal this opportunity to also ask a question?
Yeah, sure. And then we go back to Tola question because she posted that in the chat. But yeah, sure,
I wanted to ask Rachel. I don't know if I maybe misunderstood you, but you said the caravan must just be in place, and then they are occupying, and then whatever proceedings must happen. So in South Africa, that's a big issue because often when they have these land grabs, people come and they start they erect like a piece of a house from corrugated iron or wood within a day, and then when someone wants to remove that, they say, no, they're occupiers, you have to evict us and get a court order. And that's very difficult in South Africa. So is that then very difficult if you say a caravan can just be parked somewhere? Would you need a court order to remove them, or how would that work?
Yes. So as I said, they've just taken a very fact-based approach, which is to say it's the fact of occupation of space and residing in a particular space that triggers the protection. Yes, you would have to go to court to get your order for eviction. You'd be looking for an injunction. Now, what the court said is that the case in favour of granting one of these orders would be, as they put it, almost unanswerable if you're dealing with private land. So they take the view that, yes, there's a proportionality assessment even in that situation, but the scales, coming back to your very helpful weighting of scales, are really very definitively and categorically weighted in favour of the private landowner, without any question of alternative accommodation really coming into play there, I think. Whereas if it's a public landowner, then the court is more inclined to say, well, is the public landowner doing its job in terms of providing alternative accommodation, fulfilling statutory obligations, etc. So that's where it's at. But yeah, it is interesting. I think that the court, didn't take the opportunity to impose some kind of length of occupation or degree of connection requirement in that decision, and took the view instead that it's just about presence in space. So an interesting departure, I think. Yeah.
I think that Tola, her question, what she posted in the chat, is also linked to this issue. She asks that, or she mentions that it strikes her that the pool of property rights has led to a counter effect, for example, giving procedural protection, or in some cases substantive rights, which might not have been anticipated, and how you guys view this. I know that Michel has some ideas, of course, about this, but I don't know who wants to respond first.
I'm just wondering what Tola is referring to in terms of kind of unanticipated, or the kinds of cases that might not have been envisaged. I'm not sure I'm fully following the question, but maybe if Michelle rose in.
Can you hear me?
Yes.
Can you hear me?
Yes.
Oh, great. Sorry, Rachel. First of all, for misspelling your name, which I didn't intend to. What I meant was that you mentioned in your presentation the fact that there's this trajectory between conceptions of private property rights and rights to the home or housing. And I'm wondering if we could push this a bit further and see if there's actually an intersection between the two, which gives rise to some sort of purchase, if you like, bringing forth procedural or substantive rights. And that was what I was trying to drive at. Does that help you at all?
Yeah, so I think so, and I suppose that's what I was maybe getting at with the first quote that I put up from the Supreme Court judgment, where the court was recognising that there was a mismatch, if you like, between the kind of non-ownership occupation interests that need to be protected now and the traditional legal structures of property law, planning law, trespass rules, etc. That there is now an awareness that those two aren't easily aligned and accommodated. So I suppose where I would see maybe that kind of trajectory that you're alluding to coming through is, you know, a greater awareness, a more systemic awareness of that mismatch, opening up a space where, coming back to kind of Sarah's balancing scales, at least in common law jurisdictions, we can move away from a situation where categorically and in all instances property rights are presumed to trump the non-ownership interests, the occupation interests. But we're not there yet, I think. But as I said, and I alluded to the fact that I was very optimistic about this decision, and I was talking about it with poor Kenna, and he was more dubious. And on rereading, you know, I was more dubious. But I think my optimism is not totally ill-founded, in that I think if we can see increasing judicial awareness of the incompatibility of common law doctrine with these kinds of more complex occupational interests starting to really come through, and an awareness of the marginal status of those communities really starting to come through, maybe we get to a place where that space opens up to kind of rebalance the scales, I think. Yeah, so I'm still a bit hopeful, but we're certainly not there yet. Yeah.
Great, thank you.
Michel or Sarah, do you want to respond or add something to this?
Well, I think it's really difficult for kind of substantive rights to be created without a substantive right in the Constitution. So maybe, like Michel has said, why doesn't European countries also take into account the Socioeconomic Rights Convention? So read together, that would definitely, and this would definitely help towards getting to that place. Obviously, you don't only have the European Convention, and maybe read together, this could move towards more substantive rights. But without acknowledging substantive rights, I don't think it would only ever cause delays. Perhaps when it comes to, because I think private ownership, even if we say it shouldn't count that much, it often outweighs in the unlawful occupation. Maybe if it's the state trying to evict someone from state land, like we had one of our earliest constitutional court cases. Our constitution isn't that old, but one of our earliest cases actually was a denial of an eviction where the land was actually privately owned but not used. It was kind of abandoned, and the state had brought the eviction because people were complaining in the neighborhood of this squatter, this settlement. And so the court denied the eviction, and that actually gave rise to some kind of substantive right. We also have had cases where the eviction was denied on private property, but then usually the state is required to pay the private owner. So it's not only a denial.
We have one more question by Alison Gold, and I want to propose that this is the last question because it's been 5:30 at least here in the Netherlands. So Alison, please go ahead. The last question of the session.
Thank you so much for the opportunity. It's been a fascinating presentation. I teach at Wake Forest University in North Carolina in the United States and have practiced as a housing and tenant lawyer for over a decade in the US. And the proportionality is such an interesting approach because it's very different than an American approach to displacement. And one of the questions that I had for the speakers was in talking about how the court oversees these processes in different countries and how rights are upheld. If there is either a right to counsel, or if the either squatters or the persons who would be evicted from these properties or these lands, if they have a right to representation through the process, or what is in place to ensure that their rights are upheld while the courts are evaluating and looking at these kind of the different interests at play in these cases. We don't have a right to counsel in housing cases in the United States in most jurisdictions, but it's something that more and more we are looking at across the country.
I might jump in there, Alison. A really interesting question. I mean, I think it's a huge problem. I know there's been really great research done in the UK from Sue Bright and Lisa Whitehouse around, this question of access to counsel, awareness of entitlements and rights, whether, and I think what's crucial in certainly the Irish context, and I think more generally, and Sarah alluded to this, in the ECHR context, it tends to be that the onus is placed on the displaced person to raise these rights as a defence, rather than, as in the South African context, as I understand it from Sarah, that there's an onus on the court to satisfy itself as to the fairness, the proportionality of the eviction. I think that's crucial, because if the onus is on the displaced person to take the initiative to raise the argument as a defence, then absent legal counsel, and really good legal counsel, let's be realistic, that's not going to happen, and these arguments just won't be made. So I wonder whether that speaks to Michel's statistics on kind of the low level of litigation of proportionality in the squatting cases. Maybe there just isn't an awareness there. Certainly we would have a civil legal aid scheme, but fairly limited availability within that. What can be helpful in some of these contexts, for instance, the traveller occupation cases, is good NGO groups, and I suppose in the Irish context it's a relatively small population. So where these cases come up, there can, at least in some instances, be enough NGO backing to take litigation on at least some of these cases. But roll that out beyond that narrow context to, for instance, private residential tenancies more broadly, and there's no way you have that kind of access to legal advice and legal support. So I think that's absolutely fundamental to the debate here, and possibly fatal to the usefulness of some of this on the ground for people. Yeah, absolutely.
Thank you so much for this very interesting question. And I think that one of the best things about these webinars or seminars, or how you want to call them, is that it offers such a great opportunity to have these different perspectives from different countries, different legal cultures, different continents on the same topic and the same issues, and to see that the issues are widespread, but the possibilities that exist to tackle these issues are quite different. Michel, you have your hand raised.
Yeah, so to answer Alison's, but I know I will only talk for like a minute, right? So I think Sarah or Rachel already mentioned it. I was also, why do the 70% of the squatters don't go to court? Because there's no right to counsel. And in the squatter cases, they actually need to do something, right? So they need to go to court and ask for a ban for the eviction. So that's also an explanation why only 30%, but still it's 30% that go to court, which is actually like a considerable number. And they are usually supported by NGOs, activists, lawyers, and so on. The majority of evictions take place in the private or in the rental sector. Then majority of tenants don't show up. So I think in 90%, so they don't have a right to counsel, or they don't have a right to counsel. But if they show up, the majority, almost 90%, have a lawyer. And you see a correlation between having a lawyer and advancing this proportionality. Still, what we find is that if they do so, they have a higher chance to lose, which is an interesting finding. But you can explain it in such a way that landlords, especially public landlords, wait longer before they actually go to court, and therefore they have a stronger file. Right? There is a larger number of months in arrears, or there is more nuisance behavior, or there is something else they did wrong. So they enjoyed protection, but then basically they delayed the eviction. And then when they end up in court, they can still rely on Article 8 of the European Convention, but it's too late, basically. That's my hypothesis, right? Alison, I don't hear you because your microphone is muted.
Oh, I'm sorry. One of my students is in the room with me, and we were talking about your answer. It's very fascinating. Thank you so much.
Thank you all. I would like to wrap this session up. Thanks, everyone. And of course, special thanks to Rachel, Sarah, and Michel for these very interesting presentations. And I think that this format in which we have 3 presenters is a huge success. So we will definitely organize these sort of sessions in the future more often. Thanks again. And for the people on this side of the world, have a nice evening. And for the rest, have a great day. And hope to see you at the next EVICT session. Bye-bye.